Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here on this station every Sunday from 8 to 9 a.m. to bring you, the Pennsylvania landowner, the information that you need regarding natural gas development. And as I hope you know, that I, Doug Clark of the Clark Law Firm, have not, do not, and will not represent gas or pipeline companies. I represent Pennsylvania property owners, Pennsylvania oil and gas right owners. I have not, do not, and will not represent oil and gas or pipeline companies. I represent landowners for oil and gas lease negotiations, all types of reviews, consultations on all contracts, any and all contracts related to oil and gas development. Of course, pipeline right-of-way agreements. At this point, I think we can safely say that I have negotiated, reviewed, consulted with, worked on pipeline agreements with over 70 separate companies. 70 separate companies who have operated or are operating in Pennsylvania. So gives you an idea of the type of work and experience that there is out there and the types of, or the number of pipeline agreements and activity. And I'm sure that we'll continue to see more as we go along in the future. I also represent clients and landowner property owners for unitization issues, royalty issues, breach of contract issues. We're starting to see some more of our prior clients, and other landowners, gas right owners who never were clients, starting to receive some royalty checks, and we do more and more estate planning to make sure that you have the individual plan that is right for you, with the same as all these agreements, whether a gas lease, pipeline agreement, estate plan, surface use agreement, whatever that agreement may be, whatever the situation may be, you need what is right for you, specifically for you, not a cookie cutter plan, a cookie cutter agreement. When you negotiate these agreements, everyone is in a different position. You may be in a different life position. You may be in a different leverage position. But it is critical that you assess and understand your position and that you make the right decisions for you and your family, because these decisions are typically going to last for many decades and into future generations. So many times we get one chance to do these things right. Let's do them right. You're listening to Attorney Doug Clark. This is All Things Marcellus. You can always contact the office, 570-307-0702. I also want to take this opportunity to remind everybody that I represent property owners, gas right owners all across Pennsylvania. Whether you live in another state or a different country, if you have oil and gas rights in Pennsylvania, property in Pennsylvania, well, we can probably help you out. And so I want to make sure that people do not get discouraged by distance with today's technology, faxes, even U.S. mail with many clients, email. We are able to effectively represent clients all over Pennsylvania and beyond. So I really want to encourage people, because I have, as an example, you hear me talk about Tioga County a lot because it's a really active area in the state. I have many active clients. I've had many clients from Tioga County, and even though there's a distance there, it's consistently proven not to be an issue. And I can tell you this, that in any case, if I feel as though I can't assist somebody, if I feel that the representation is beyond my scope or expertise, I am going to tell that client as soon as I have that feeling. If I feel that distance is going to be an issue, I am going to tell that client as soon as I have that feeling. Rarely, and I mean rarely, does that occur. So I really want to encourage people. I do these reviews and consultations. I'm going to talk today about multi-unit well forms and the consent that the company is requesting in Cabot and Susquehanna County. But I'm also going to touch today, so don't leave me, because I'm also going to touch today in the Tioga area. But again, these things go beyond just this specific topic. They are your specific information about the topic, but they're also general concepts that override all of these things, meaning how the companies operate, how they approach people. So maybe you do not have a multi-unit well consent request pending in front of you, but if you're leased to Cabot, there's a good chance you may, or you may in the future. So you want to pay extra special attention to the specific information. However, we're also going to talk about how companies send these letters to people. Send letters and documents and say, oh, here, sign and hurry up and return it back to me. So whether it's a multi-unit well consent form, or whether it's a pipeline right-of-way agreement, a lease amendment and modification, whatever the case may be, it's often that you see the same type of technique. Send it to you, oh, hey, everything's going to be great. This is really good for you. Here, sign here, get it back to us. Everything is great. That is a common way in which companies operate. And we need to be smarter. We need to be smarter. Another theme of today's show. We have to be smarter. Why would we just sign contracts, legal contracts that are sent to us in the mail that we need to notarize and return back to the company? Why would we do that without consulting with someone who's working for you, without understanding what you're signing, and without fully understanding the impact to you and your circumstance? Not some sort of generalized impact of how this, in this case, multi-unit well consent form may impact you or others. But remember when I said people are in different positions. And I'll tell you this, if you have a multi-unit well consent form, there are many other people around you, physically around your property, that have that same form. And look, you are not, we're going to repeat this, you are not in the same position as all the other people around you. But you get the same canned letter, the same form letter, the same canned speech. But you're not all in the same position. And that's where you need individual, specialized information by somebody who understands these issues and can guide you as to why would you maybe want to sign this document, or why you may not want to sign this document. But again, what is right for your neighbor isn't necessarily right for you. And in many times, it's not right for you. And in many times, your neighbor makes a bad decision. And I'll tell you this, because my neighbor made a bad decision, I don't want to make that same bad decision too. I want to learn from that decision. We can look back at the history of offers for gas leases, of pipeline offers, how they have evolved over time. How they started at $5, $10, $15, $25 and went up to $6,000. They started at 12.5% and went up to 20 and 21%. And a lot of people, when they got that first contract, hurried up and signed. And later they learned, boy, I wish I would have taken some time. I wish I would have talked to somebody that knew what they were doing. I wish I would have waited and learned and understood what this was all about, so I could make an informed and intelligent decision. And those people who didn't do that, virtually every one of them, if you ask them, would, and if they don't, they should regret that mistake. So we need to learn from mistakes, correct prior mistakes as we go forward in the future. So when we get a document in the mail saying, here, sign this and return it. And I'm going to tell you, you can read this stuff, and boy, you better really know what the heck you're doing, because you're not going to understand it. Because I'll tell you, the first time I read it, I had a hard time understanding it. I had to read it many times. And I deal with this literally every day. So we need to make sure we're getting you the right information to be informed for your situation, not your neighbors, not the guy down the road, your situation. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me right here at this time every Sunday, 8 to 9 a.m. on this station for All Things Marcellus. You can contact my office. You have a multi-unit well consent form. Contact the office. Learn about a review and consultation. 570-307-0702. These usually take about an hour of time from somebody working for you, not the gas company. Remember, the landman sitting at your table saying, oh, yeah, here, this is great for you. They're working for the company, not you, the landowner. So multi-unit well consent forms, give us a call, learn about a review and consultation, because people are signing these things where, honestly, my opinion in the cases, and again, not specific advice for anyone, boy, I wouldn't sign it. Again, that's not specific advice for anyone, but we'd need to talk about your case and what your options are and the pros and cons. Do you sign or don't you sign? What is right for you? And that's what you need. You need specific advice. You can call me, Doug Clark, Clark Law Firm, 570-307-0702, or honestly, call someone else if you don't want to call me, but call somebody working for you, not the gas company who's trying to get you to sign this document. Okay, back to this multi-unit well consent form. And again, I'm going to get into some more details here as we go through. But my overall point to start is, how are these agreements being presented? And remember, this is the same thing if it's a pipeline agreement, a gas lease. Boy, I'll tell you, this is complex stuff to understand it. And the company, in my opinion, is going to want to try to make this like, oh, it's not very complex. Here's the deal. Sign, you get more money. Well, we've heard that before, haven't we? Sign, you get more money. Listen, if it's something that you sign and you get more money, well, who's against that? But we need to check on that. We need to check on that to make sure that's accurate. Or maybe if you sign, you can negotiate. You can negotiate for additional wells to be drilled. Maybe you can negotiate for money. Who knows what you can negotiate for? But I can tell you this, if you're just signing, well, you're not negotiating. And you need to make sure, you need to look at every single time, my opinion, every time you are presented with a document from a company where they're asking you to sign that document, you need to get it reviewed, and you need to look at it as a potential opportunity. It is a potential opportunity. Now, after it's reviewed, and I look at some documents, sometimes people will send me a permit form, and we'll look and say, hey, look, this is really simple. I would have no objection. Go ahead and sign. No reason not to. It takes a couple minutes. Or somebody sends me a reviver agreement. They send me a multi-unit consent form, well pads on their property. And I say, whoa. We need to talk some more, because there's probably things you can do here. And if you didn't make that call, and if you didn't send that document, and you just signed, you're probably missing out. And the question then becomes, how much are you missing out on? And we're talking about multi-unit consents here, multi-unit well consents. But look, this same thing applies. Pipeline agreements, road agreements, meter station agreements, and so on and so on and so on. If you are just signing documents and not getting assistance from somebody who knows what they're doing, you're most likely signing an agreement that could be made better by language, and in many, many cases could be negotiated for additional money. But you're never going to know that unless you talk to somebody who's working for you, not working for the company. It drives me crazy where people still, after years and years and years of seeing landowners, in my opinion, strong opinion, being taken advantage of due to their lack of information, not the lack of intelligence, a lack of information, and they're being taken advantage of. And this has easily happened most intensely over the last decade, where people are taken advantage of for a lack of information. We need to learn from that. The problem is people are touching the hot stove after they've already been burned once. We need to learn that when we touched that hot stove the first time, we got burned, and we're not going to do it again. So when we sign a lease or we sign a pipeline right-of-way agreement or any other document without having it reviewed by an attorney who knew what they were doing, without understanding how it would truly impact me today and into the future, without understanding the royalty and royalty calculation language, without understanding in a pipeline right-of-way agreement that I could say no or negotiate for more money, without all of that information, I signed a bad deal. And if I had that information, many cases, the person could have either rejected an agreement that they weren't interested in, negotiated, and often for hundreds of thousands of more dollars. And again, look, we can't say this is every case, but boy, it happens a lot. It happens a lot. And the problem is you'll never know if you never reach out and get that assistance, get that check. And that's why I don't want to be commercial, but that's why these reviews and consultations are so helpful. So like, for example, an amendment, gas leases, pipelines, anything, before you sign, I would so strongly encourage you, have a review and consultation. They usually take 2 hours or less, by including the review time and the telephone call or the in-office visit. You're making a big mistake, in my opinion, if you don't do that. And again, I'd love to do it. This is what I do. I do it every day. Hopefully, you can sense that I'm passionate about representing Pennsylvania landowners and gas right owners. So I'd love to try to help you. But if you don't call me, call someone. We got to stop. We have to stop signing these bad agreements. And the reason why we're signing bad agreements is because we do not have good information. We are relying on the company landman who we know, if we listen to this show, works for the company, not for you, the land owner. All right, we're at the end of the first segment. You are listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm right here on this station every Sunday, 8 to 9 a.m. to bring you the information that you need regarding natural gas development. And if you have a multi-unit well consent form, give us a call, 570-307-0702. Get you scheduled a review and consultation. Again, beginning to end, usually an hour, maybe less. I think it's worth the time. Check it out. Give us a call, learn. 570-307-0702. Love to help you out on this. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, I'm right here with you every Sunday, 8 to 9 a.m. right here on this station, All Things Marcellus. And you can always call the office, and I encourage you to learn about reviews, consultations, all the other work that we do. Represent clients for gas lease, pipelines, royalty issues, breach of contracts, gas lease amendments, multi-unit well consents. You name it. Related to natural gas, give us a call, 570-307-0702. Check out the websites too, pagasleaseattorney.com, pipelineattorney.com. I'm going to repeat that. Check out the websites, pagasleaseattorney.com, pipelineattorney.com. We need to get this information out there, and we need to have you guys all sign the best possible agreements. So, okay, let's jump back in here to the consent to multi-unit wells. So what does that mean? So what it is Cabot in Susquehanna County is presenting to landowners, and I mean lots of them, probably into the hundreds of landowners, documents actually the main document is called a consent to multi-unit wells. Consent to multi-unit wells. Well, most people aren't going to know what that means when they hear that. And what happens is, well, how do you hear about this? How do you know? Well, here's this guy talking about it. I hear this Doug Clark guy on the radio talking about it. Well, what in the world does it mean? Well, what happens is, normally how it starts is you get something in the mail. and you get a letter from Cabot. And the letter from Cabot talks about how great this is for you, essentially. So it talks about, hey, we as a company can drill longer lateral wells, meaning that in these horizontal wells, they'll drill down, say, 5,000, 10,000 feet, and then they go out laterally, parallel to like the surface of the earth. So they're going outward. So you go straight down and then out. Think of it like a letter L. So we got the going down, and we have it out. So the bottom portion of that L, they're saying, hey, we can drill that lateral L. We can drill that much, much further. We can drill it much, much further. But your lease says that your lease says that you have a 640 acre unit maximum. That's typically the case with these Cabot type leases. So they said, we'd like to get your consent to allow us to, and now listen, this gets back to why you need specific advice, because everybody can be in a different position, and it gets very, very technical. Very technical, and that's why you need somebody on your side who's explaining it to you and how it can be good or bad for you individually. So let's try to create a mental picture. We have the well, which we're going to say looks like a letter L, and the top of the L is the surface of the earth. So we're going to drill down, and I'm going to use nice, easy numbers. We're going to go down, we'll say 10,000 feet, straight down. So that's the top part of the L. Now we're going to turn that well, and we're going to go horizontally, and let's say we're going to go another 15,000 feet. That's a long way. We're going to go 15,000 feet. So as we go horizontally, when that L, if you think about the L, it's coming down, and then we have the horizontal portion. Well, if you're at the place where the L just turns to go horizontally, you're then close to where the vertical portion of the well comes down from the surface. So you're real close to the well pad or at the well pad. Now, as that L, the bottom of the L, goes out, or the horizontal well goes out 15,000 feet, it's going through many different properties. Well, let me tell you, if the well pad is on your property, you're in a unique situation. And I'm going to tell you this. Strong advice, you better not be just signing these forms. In my opinion, you better not just be signing these forms. If you have a well pad on your property and you are presented a consent to multi-unit wells, I would strongly encourage you to call my office, 570-307-0702, as there's things you need to know. Things you need to know, because you are in a unique position, because you're going to end up having the well site, which is already on your property, but longer wells. You're going to see more truck traffic. There is going to be a difference to you than there is to every other person who's presented with the consent to multi-unit wells. So you especially should not just be signing these documents. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So that's just one. So let's go again. So we're coming down. We have the vertical portion of the well. Now it's turning sideways, and we're going out horizontally. If you are closer to the well where it is coming down vertically, so well comes down vertically, then turns and goes out horizontally. Well, the people who are closer to that turning point, those people may have a very, very different position than the people who are all the way at the end of that horizontal well. Their position and their interest in whether this occurs or doesn't occur may be quite different than the guy at the end who may, and I cannot stress this, may say, hey, look, I may want to sign something like this because if I sign it, they will drill a longer well and I will get royalties from the longer well. If I don't sign and they don't drill this longer well, I would have to wait for another well or something else to get royalties. again, I don't want to go too detailed into any specifics because that's only one consideration. Very valid, very true, but it's only one consideration. You, as a guy all the way at the end of this lateral, it may be the last thing that you want to do is to sign this form. It may be the first thing you want to do. You may say, hey, I need to hurry up and sign this, which maybe that is the correct decision. But it also may be a bad decision. It may be a bad decision because maybe if you don't sign, there's a high probability that your existing lease will terminate. Maybe your existing lease is at 12.5% royalty with full deductions, and you signed real early and it's almost expiring. And if you give the company the ability, if you give them the consent to multi-unit wells, they can start a well from a distant pad, and that may, in certain circumstances, allow the company to hold your gas lease because you signed this consent to multi-unit wells, meaning that your gas lease might have otherwise expired, to give you a better opportunity to see if you can get a little more royalty percentage, to see if you can try to eliminate deductions from your royalties. Those things are things that we need to be looking at. And I stress, look, it's not that that's every case, but boy, if you didn't take, say, the hour to have this reviewed to determine your circumstances, and you just signed a consent for no money, no consideration of any kind, no benefit, and now guarantee that your old, I'll say crappy lease, your old bad lease is now going to be extended, boy, you screwed that up. You screwed that up. And how did you do it? Why did you do it? Not because of any other reason, but you didn't have the information that you needed to make the right decision for your case. And that's why you need to talk to somebody working for you, not somebody whose total motivation is to maximize profits for the gas company. Think about it. Their motivation, I don't care what they say to you, their motivation is not to maximize money into your pocket. It's to maximize money into their pocket, the company's pocket. Now, if a side effect is that you get some more money, hey, that's okay to them. But their ultimate goal is to make the money that they can. They have a fiduciary obligation to those shareholders to maximize profits. And ladies and gentlemen, you have an obligation to maximize that agreement and this opportunity. You have an obligation to, in the way I look at it, I talk about my parents and my grandparents' family farm. I see it as an obligation to my ancestors to make sure that the land that they worked and all the things that they did and they worked in that property and how much they cherished that property and the value of that land, to make sure that I'm respecting them and doing the best I can to make sure that we're protecting that property and maximizing the income and money that can be made from that property, not only for myself, but for my children and my children's children, and maybe even their children. We have an obligation to ourselves, to our family members before us, and our family members after us. We have that obligation, and we need to make sure that we are taking advantage of opportunities that are presented. And we're not just signing documents because the company landman tells us, oh, yeah, this is really good for you. This is going to be a bunch more royalties. Going to be a bunch more royalties here. Sign here, sign here, sign here. Look, if it is good for you, there's a really good chance it's much better for them. And so then you have to ask yourself, okay, why am I doing this and what am I getting? But most importantly, you need to look at your particular specific situation. And I know that it's the same canned speech that people are getting all the time in these things. But no, you need to look at, where are you? Are you close to the well site? Are you far away from the well site? How many wells are drilled now? Are any wells drilled underneath your property now? Are they going to potentially reconfigure the unit? That you may end up receiving less royalties because you have less acreage in any production unit. These are all things that you have to investigate. There's no way that I or anyone could sit there and say, well, this is going to happen, that's going to happen, and this is going to happen without investigating your particular situation. So one of the things that Cabot has been doing is providing people with these detailed maps, which are showing where wells are drilled, where wells are planned to be drilled. And I want to say, and I want to stress that absolutely in cases, there is going to be many times where it is in the best interest of a particular landowner to sign one of these consent to multi-unit well documents. However, you don't just sign. You find out and you make sure that it's in your best interest. And then you look to see, why am I doing this now? Do I even have to do this? And as we fall back into that trap with the landman at our house sitting at our table, oh, yes, this is going to make you rich, make you rich, make you rich. Here, sign, sign, sign. Let's replay what we heard in 2006, 7, and 8, and so on. Let's replay those conversations, and let's learn from that history. These reviews and consultations on these consent to multi-unit wells, they're taking, with the review of everything and usually the conversation too, about 1 hour. About 1 hour. You owe it to yourself to learn what you need to know if you're thinking about signing this document. And then you make your decision. My job, my goal always in representation is to give my client, the Pennsylvania landowner, the Pennsylvania gas right owner, the tools and information that they need to make the right decision for that particular circumstances and for them as individuals. That's my goal. Then that person makes the decision. There are times where I'll make suggestions, times where I'll make strong recommendations, but it is always your decision. And what you need, and I'm convinced of it, is you need to have conversations and evaluations and reviews by someone working for you, not the other side. Someone whose only goal is to make sure that you, as a Pennsylvania landowner, gas right owner, property owner, are signing the best possible agreement. And that's what we do. And you can call me, call someone else, but call someone that does that fights for you, that works for you. Because people are continuing to sign these bad agreements and being taken advantage of, and we have to stop it. Now, I'm not saying the consent to multi-unit wells is this one example. I'm talking about in general. We're signing bad agreements without information that we need. We have to stop it. We have to stop it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, Susquehanna County residents. If you have a Cabot consent to multi-unit wells, if you get that documentation, I encourage you, give us a call. Talking to more and more people, we need to make sure that you understand your situation, because there's a difference. There's a difference if you have a well under you, probably. There's a difference if you're closer to the well site or if you're further away. There may be a difference. You have to look at all of the circumstances, and I'm telling you, I don't think that you're getting that information that you need. And I've been talking to more and more people, and again, they take about an hour. I know it sounds commercial, but boy, these reviews and consultations, I'm telling you, they're just very valuable to people. And look, it's a service we provide. I enjoy doing it. We want to get that information out there, but encourage you, give us a call, learn about it. Just learn about it, and then you decide. And look, again, too, if you don't call me, if you don't call our office, call an office with someone who's going to go work for you, who knows what they're doing, who isn't just seeing this for the first time, but understands it and is working for you. We have to do better. We have to make sure that we're doing better across the board. You can give us a call, Attorney Doug Clark, Clark Law Firm, 570-307-0702. Remember, I have not, do not, and will not ever represent gas or pipeline companies. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Don't forget to join me every Sunday from 8 to 9 right here in this station for All Things Marcellus, where I bring you, the landowner, the information that you need regarding natural gas development. And give us a call, reviews, consultations. If you have a consent to multi-unit well document that you're asked to sign, I encourage you, give us a call. 570-307-0702. We do these reviews and consultations, usually take about an hour. Really encourage you, get the information that you need, not the information that the company wants you to have, but also the information that you need. 570-307-0702. I want to take this opportunity to stress, because I talk to people a lot, and I'll talk to them. We'll talk about, hey, have you seen the website, or have you reviewed this on the website? And too many times people are not familiar with the websites. I really encourage you. I'm a little biased because I had a lot to do with them, but I really encourage you. Go check out pagasleaseattorney.com. Go check out pipelineattorney.com. Think about it. If you're out there and you're interested in gas development, pipelines, why not go to pagasleaseattorney.com and pipelineattorney.com? 100% free. Go there, get education, get information, learn about what we do. Maybe we're right for you. Maybe your lease review consultation, pipeline review consultation, more involved representation. We do much, much more than that. But we got to have people taking advantage of the websites. Another thing with the website, the radio show. I've been doing the radio show now since 2010. I know you may get tired of hearing that, but since 2010 is when I first started doing this radio show, All Things Marcellus. And there's plenty of information. We always have something to talk about. I have a scroll of topics that I could unwind here that I can talk about for the rest of this year. I have enough topics for the rest of this year. So listen to the radio show, but if you can't listen each weekend, go to pagasleaseattorney.com, go to pipelineattorney.com, read the information, check it out, but also we post each week's radio show on the websites on Monday morning. So if you can't tune in on the weekend, for some reason you can't make it, you can always go during the week. pagasleaseattorney.com, pipelineattorney.com. And it doesn't end there, because if you go on vacation and you miss a couple weeks, we archive the radio shows. So there are many, many hours of radio shows that you can go back and listen to for free and get good information. But remember always, the radio show is never specific advice for anyone. The radio show is designed to be informative, to get you thinking, to be talking about topics that you should be aware of, and to make sure that you're thinking about what we need you to be thinking about. But it's not specific advice. To get specific advice, we gotta have you call the office, enter into an agreement, but we want to get you good quality information. That's the goal. That's a big part of the radio show, and that's a big part, if not the biggest part. But then also the websites. They're designed to get you good quality information. And of course, we hope you like what you read. We hope you like what you hear. We hope you give us a call. I want to help you, and we want to do what we can to make sure that you're doing the best that you can and signing the best possible agreement. So we'd love to hear from you. But even if we don't, take advantage of the information on the websites. Take advantage of the radio show. Raise the bar for you and everybody else. That's what we want to do. That's what we want to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So I want to talk a little bit more about this consent to multi-unit wells. Again, it's really specific. We have to look at your specific case. We got to get these maps. We have to understand, where are you within this unit designation? Where are you? How far away are you from the well site? Are you at the well site? Is this going to be to your benefit or not your benefit? And then here's a question you always have to ask yourself. Why am I going to sign this document? And if the answer is, oh, we're going to get you more royalties, going to get you more royalties, you should probably ask some other questions too. Okay. And I'm not saying that's not possible I'm not saying that at all, but I'm saying that the easiest way to get someone to sign a document, other than just giving them money at the time, is saying, you're going to get rich. You're going to get a lot more money in the future. Here's my pen. Here you sign. Here, I'm a notary. I'll notarize it. We have to ask the right questions. And if it is right to do, then by all means, let's do it. But if it's not right to do, let's not do it. Or if it's right to negotiate to make it better and then sign the document, well, then let's do that. But let's do what's best for us. Let's do what's best for you, not what's best for the company. Again, this is All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always give us a call, 570-307-0702. So now, looking at the actual form document, consent to multi-unit wells. Just one thing I want to touch on, this is a very complicated document. One of the things to touch on, though, right down at the bottom, I'm going to read one paragraph to you. This is a great indicator of why you need to be paying attention. So one paragraph says, operations for or production from any multi-unit well shall constitute operations for or production from the lease. Now, I imagine that most people that just heard that may have no idea what in the world that means. And I'm going to tell you, that's a pretty darn important sentence. And most people aren't going to know what that means. And that's saying it gets back to, and again, you have to look at your case specifically, but it gets back to, if you sign this, it is possible, and I'm not saying this in all cases, I'm just saying this is possible, that if you sign this, you may be extending a bad lease that would otherwise expire. Maybe. Not saying yes, but we have to look at your circumstance. And there's a reason why that language is there. And it very well could be that by certain people signing this, they've now locked in a lease that they could get a better lease if they didn't sign. Again, I'm not saying that's across the board, but I'm saying that's an example of something that we need to look at before you sign the document. Next sentence, same paragraph. The terms of this consent, listen to this, and man, this should give you red flags all around you. Pop, 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 pop. All around you should occur. The terms of this consent will control in the event there is a conflict with the terms of the lease and or any declaration declaration of pooling. I'm going to read that again. Because I screwed it up. The terms of this consent will control. So this document will control in the event there is a conflict with the terms of this document compared to the lease and or the declaration of pooling. Man. So, in other words, what you're agreeing to when you sign this, if there's a conflict with your lease in this document controls. If there's a conflict in the declaration of pooling in this document controls. Probably 80 to 90% of the people out there are not really familiar with the declaration of pooling, not understanding what these documents do, and saying, oh, well, wait, I got this nice cover letter. Oh, you're going to reduce the footprint environmentally. We're going to get more money. A guy came out, told me money, 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 royalty, royalty, royalty. Where do I sign? How about this whole part here, sir, where it says the terms of this consent will control in the event there's a conflict with the terms of the lease and or any declaration of pooling. How about that? We're not talking about that very much, are we? We're talking a lot about future royalties, which may or may not ever occur. We're talking a lot about that, but we're not talking so much about possible conflicts between this document and my lease. Also says the recitals are incorporated into and made an integral part of this consent. Most people have no idea what in the world what a recital even is. So again, my point here is, and I don't want to, I'm not saying that the consent to multi-unit wells shouldn't be signed. There are cases where they definitely should be signed, but there are cases where they should not be signed, in my opinion. Absolutely should not be signed, in my opinion. And you need to know what is your situation. And you should not be relying on the company to tell you what your situation is. Because I've been doing this for a while, and my experience isn't that the company doesn't come out and lead and say, well, landowner, yeah, this isn't so good for you. You're going to see more truck traffic. You're going to maybe see the well pad last for years longer. This is going to be an inconvenience to you. You're going to see wells that are going to be drilled that you're going to have little to no benefit from. So I really, if I were you, landowner, I would not sign it, or I would ask for some money or do something. That's not what you hear. It's not what you hear. And I'm going to tell you, you need someone working for you. So whether it's me or someone else, you need someone working with you on these issues. All right, we're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're going to keep pounding this number into you. Give us a call. Reviews, consultations, consent to multi-unit wells, pipelines, amendments, you name it, breaches, royalty issues, 570-307-0702. Clark Law Firm, 570-307-0702. Have not, do not, and remember, will not represent gas or pipeline companies only. You, the Pennsylvania property owner, landowner, and oil and gas right owner. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each week at this time on this station for All Things Marcellus, where I bring you, the Pennsylvania landowner, the information that you need, not the information the company wants to give you, but the information that you need regarding natural gas development here in Pennsylvania. And so I want to talk about offers, and I've been doing these reviews in Tioga County, people being offered leases when they already have a lease that is what we call held by production. But they're offered a new lease. And in some cases, their old lease may be 15% royalty, and the new lease is also 15% royalty. But one I looked at the other day, the landowner was offered $2,000 an acre in a per acre bonus payment, but the same royalty percentage. So why? Why would you be offered that when the company doesn't need to offer you that? And maybe the landman says, oh, well, it's taking a long time to develop this, so the company's looking to, do something for you. Maybe that's said to you. Maybe it's not. Who knows? Ask the question, why? Why would you be giving me a new lease when I already have a current lease in place? And then also, you need to study in very close detail the terms in your existing lease, which is actually held, that's a part of a unit, and then compare that with the new lease and see every single place it's different. And I will bet you, pay close attention, write this down, go back, listen to pagasleaseattorney.com, go to pipelineattorney.com, check out the show tomorrow. Go back, re-listen to this. Look at paragraph number 4. Paragraph number 4. Look at your original lease language. Paragraph number 4, royalty. Look at your original lease language. Look at the new language in your new lease form. You're going to see it's pretty darn different. You're going to see that your new lease form has written in black and white a royalty calculation method that, in my opinion, is going to be very detrimental to you, the landowner, for decades upon decades. So, here's your carrot, landowner. Here's a $2,000 per acre bonus offer. $2,000 per acre. Nothing to sneeze at. That's your carrot. But the stick, which you may, again, not specific advice for anyone, but the stick that you may be getting beat with for the next 50 to 100 years is going to be royalties with deductions for pipeline gathering, transportation, compression, or other fees. And there's a really good chance you're going to find that the company that produces gas under your lease, under the new lease form, is going to sell that gas to an affiliated company of their own and then use an index price to set the value of the gas. Oh, and then, by the way, they're going to bring out a bigger stick yet again and beat you with deductions from that index price. So the $2,000, that carrot may look very attractive. Again, this is not specific advice. That's why you need reviews, consultations. You need to understand this. This is just getting you to think. That carrot may look big and juicy, like you're a rabbit. You say, boy, that looks nice. But man, you may take a beating for the next 50 to 100 years in royalty payments. And I'm not saying this is going to happen to you, but many people saw deductions totally take up all of their royalties. Totally. Meaning, gas was produced and sold, and the landowner got no royalty check because the deductions for pipeline, transportation, gathering, and other fees actually exceeded the price that the company got for the gas. Now, again, this isn't everywhere, but that has occurred. It has occurred. So you better darn well be aware of that. And here's the thing. This is one of my favorite things that I heard this past week or two. I think it was this week. Yeah, the landman told me that Shell or SWEPI's deductions, they average 2% of the royalties. First off, let me make something very clear. I don't believe that. Prove me wrong. Be more than happy, but I absolutely do not believe that. But how about this? All right, if you average 2% royalty and you're offering me, or 2% deductions, and you're offering me 15%, I have the deal. I have a great deal for you, company. How about you give me 12.5%? So 12.5 is 2.5% less than 15. 12.5 plus 2.5 equals 15%. So how about we do this? Since your deductions only average 2%, how about you give me 12.5% and not take deductions? I'll give up my 2.5% royalty, and I'll just take 12.5 without deductions. Well, I'll tell you this, that ain't going to happen. They're not going to say yes. And the reason why is because if somebody's telling you royalty deductions are 2% on average, be careful. Be careful, because I don't believe that's true. And that's, again, it's just another example. You need to have somebody telling you what you need to know, not what the company wants you to hear. And the same holds true with the consent for multi-unit wells and any other document or agreement that you're presented with. We need to get you, the landowner, information from your side, not the other side. Not the other side. And we can't fall into the trap that the other side is looking out for us. We need to look out for ourselves and get our own advice so we make the right decisions for us. Remember, we need to stop signing bad agreements, and always remember that the gas and pipeline company landmen work for the gas and pipeline companies, not you, the land owner. Have a great week, everyone. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and we'll see you back here next Sunday from 8 to 9 a.m.